My Lord, the full minister of the state is Jacob Zuma and another.
May it please the court, my lord, I appear on behalf of the state, together with my colleagues Matenjwa and Ms. Kutsila.
And please, Your Lordship, I appear on behalf of accused number 1, Mr. Jacob Zuma, together with my learned friends, Mr. Musi Sikhatani, Mr. Davi Jubir, Mr. Mani Masuku, and Mr. Mpilo Sikhatani.
My Lord, I appear on behalf of accused number 2 with Ms. Adhikari. Your Lordship will notice that in the accused dock is only one person. On the previous occasion, Your Lordship excused my client from having its representative in court. So I place that on.
May it please the court, my lord, I think it's appropriate that we go first for the state. My lord, the court will remember that at the last appearance, the matter was postponed, despite the fact that the state at that stage was ready for trial. We place it on record again that the state is ready for trial, and as we all know, the Judge President had given us the date of the 12th of November for trial, so that is notionally possible. But Your Lordship granted the postponement because, for the following principal reasons, in respect of accused number 1, Mr. Zuma, there were problems with financial instructions, and clarity was sought from the presidency about the funding of Mr. Zuma's legal expenses. That matter has, in the interim, we are informed, that matter has been resolved, and Mr. Zuma's team now is properly instructed and ready to proceed on that basis. So that issue has been resolved. As far as accused number 2 is concerned, the matter was postponed for the outcome of representations which accused number 2 had made to the National Director of Public, or rather to the Director of Public Prosecutions, to have the matter withdrawn for the reasons given in the representations. That matter has also been resolved in as much as the representations have been turned down, and it has been decided on behalf of the National Prosecuting Authority that the matter should proceed. So those 2 issues which were holding us up have now been resolved, and so once again the state is ready for trial. It was envisaged at the last postponement, Your Lordship will remember, that both parties had indicated that they were considering bringing permanent stay applications, depending on the result of, number 1, the financial instructions, and number 2, the representations. Both parties have indicated to the state that they do wish to bring permanent stay applications, and that matter must then be resolved by the court. That being so, we as the state and as the 2 defense parties have got together to see if we can't work out some sort of acceptable timetable in terms of which we will exchange papers by certain dates and answer those papers, and if necessary reply, compile heads of argument, and then ask either this court or the Judge President to set a date to hear the issue and determine the 2 permanent stay applications. My Lord, we're not far from each other. Unfortunately, we're not in a position to state that we have agreed on a timetable. And let me put up front, my Lord, what the problem is. My learned friend for accused number 1, Mr. Zuma, wants a date, as we understand and as he's informed us, in mid-November for the filing of their papers. My learned friend will no doubt address you on why that is. We say, my Lord, that we regard that as too long, that under the circumstances, given that the issues are more or less known, they have formed. Look, we don't know what the representations are going to consist of. We haven't seen them yet. We can only imagine that they will traverse issues which have been traversed in the representations, which were lengthy and which caused delays. We can also only imagine that they will also traverse issues which in some or other respects have been adjudicated upon in various courts in this country. from the High Courts to the Supreme Court of Appeal to the Constitutional Court. We can only imagine so. But what I'm telling your Lordship in short is that we would think that mid-November is too late. It delays the matter too much, and that would push us in for a hearing sometime into the first term of next year, 2019, which we would also we would want to avoid. We would want to work out some way of getting it done earlier, with hopefully a hearing in theory sometime this year still, so that the permanent stay could be resolved then, so that we can get onto trial, which we're so keen to get to. So that in short is the state's attitude. As far as accused number 2 is concerned, there's not as much disagreement. There's no firm agreement, but I think we can say that there's no substantial disagreement. Let's put it that way. My learned friend for number 2 will no doubt address you further on that. As far as so your Lordship will determine what the appropriate date is in terms of which my learned friends must be put on terms to file papers in respect of the permanent stay application. We would ask that your Lordship consider a month from now, a month to 6 weeks, and that would bring us to the end of August, early September, and then we could get on to filing papers in answer, which might enable the Judge President or the Judge presiding in this matter to set a date for hearing earlier on. That being so, there's one thing on which all counsel agree firmly, my Lord, and that is good news. That is that whatever the outcome of your Lordship's order relating to the filing of papers, we think that a holding date for the criminal trial of the 30th of November would be appropriate. We've discussed that at length, and we all think that whatever your Lordship's order relating to the permanent stay applications, we need the holding date this year so that we can see where we are, resolve issues, make applications, and get further orders from the court as necessary. So the holding date of 30th of November we agree on. What precisely will happen on the day will depend on your Lordship's order now and how what progress we make in respect of the permanent stay application. So I think, so that once again, the state is more than ready for trial. And perhaps I should just mention one final point, my Lord. The National Director, in declining accused number 2's representations, indicated that he was considering adding a further charge to the indictment or making application to the court for an amendment to the indictment. We, as we now stand, have made recommendations. We have not been able to resolve the issue finally with the National Director because the indication was given only a number of days ago. But we would, from the prosecution side in this court, assure the court that that is not an issue of substance as we see it, and in all likelihood it will not play a further part in the progress of the matter as we go on from here.
Adding another charge to accused number 2.
To accused number 2, as we understand it, it is being considered that a further sub-count to one of the alternative counts in respect only of accused number 2 is being considered. That's as far as it goes.
In the light of the history of this case, do you think 1 month will be adequate for the defense to put everything together for this application?
Well, my Lord, that is our firm application, and we do that. We don't do that lightly. And my Lord, to be quite frank, the best point, which I think my learned friend would make, and the most difficult point for us, let's put it up front, is the fact that there's a new team. That we concede. There is a new team. Mr. Kemp has retired. My learned friends have now been instructed afresh. That is so. Why there was a change of attorney would seem to be an issue which we think should not really have affect the conduct of this case. But that being so, the issues which we can only imagine would be put in the permanent stay application, we would think, are issues which have largely been in contention between the state and Mr. Zuma in various forms for a very long number of years. And the notion to bring a permanent stay application is not new. The issues which are sought to be resolved, so we would imagine, are not fresh, and it would be expected that the material available is material which has been collated, traversed, put into papers, answered, replied, and we would think that giving it a diligent effort, a team as big as my learned friend's team would be able to put something together and should put something together in a time shorter than the middle of November. We're now July, that's August, September, October, November, 3.5 months for issues which we would imagine are
July
ready.
is at the end.
My Lord?
I say July is at the end, you may not even count it.
Yeah, so August, September, October, November, so it's 3.5 months.
All right. Are you through?
So my Lord, that is the state's request, and we ask that the court take it into account in deciding what an appropriate time period is. But we can't agree that 3.5 months is reasonable under the circumstances.
Okay. After receipt of the application, how long will you need to respond?
And in terms of that, my Lord, I must place on record that between counsel for the defence, both parties and the state, we're all in principle ad idem that reasonable time periods need to be given. We're not going to be bound by, we're not going to consider each other bound by rules of court formal if such apply. But reasonably speaking, depending on the nature of the representations and the issues which arise from them, we would need some time. So we would think if we require 30 days from them now, we would think that a month would be sufficient for us.
Sufficient.
Yes.
Okay.
So I think, my Lord, unless there's anything further at this stage, I think that really is the state's application. So the application in short from the state is that this matter be postponed to the 30th of November, that we all agree on, the criminal case, and that the court now issue orders and place the parties under obligation to file by a certain date. We want an earlier date rather than a later date, and we would suggest a date more in the nature at the end of August or the beginning of September, rather than the middle of November, given the history of this case. Okay. Sorry. My Lord, yes, we jumped up and didn't give my learned friend who's standing in for Mr. Hully to excuse Mr. Hully, so perhaps we should give her that opportunity.
May it please the court, my lord? I appear on behalf of Mr. Hully in this matter. Mamvura initials GM for the record. My instructions are to formally place it on record today that Mr. Hully is no longer the attorney of record of Mr. Jacob Zuma, accused number 1.
So you want to be excused?
Yes, my lord.
Is there any objection?
No objection from the state side, Lord.
Okay, Mr. Hully's excused as technical representative of office number 1.
As the court pleases.
And you also, you may be excused unless if you want to sit in and listen to the further proceedings if you wish.
Yes.
But in any event, you are excused.
As the court pleases.
Okay, Mr. Ellens.
Thank you, my lord. Mr. Dana, I'm sure inadvertently was a little presumptuous. It says he wants to get this application for a permanent stay heard so that he can get on with the trial. Well, that rather presupposes that the permanent stay will not be granted and has no prospect, and we hold a very contrary view, but I'm sure that was just a slip of the tongue. And my lord, we are a new team. We have a new attorney. I'm not sure why Mr. Dana suggests that the change of attorney can't make a fundamental difference. We take instructions from our attorney. We are guided by our attorney. We are subject to some extent, the dictates of our attorney. He's an essential part of our team, and he too is new to the matter. We are all new to the matter. We have taken diligent steps once briefed, once it became clear that Mr. Kemp had decided to retire from the bar. And it's a very significant factor. He has a tremendous historical history in the matter, which we do not have. We've sat for nearly a day with him, 2/3 of a day. His office is half full with documents relating to this matter. We gleaned what we could. We hired a motor car to transport all the core of what we think we need from Durban to Johannesburg. We set about assessing information that we thought we needed and wrote a letter to the state the day before yesterday. It's a substantial letter, and it sets out what documents we need to chart our way forward. We don't suggest that the state should have answered that letter already, but we did it as a matter of necessity. We did it as a show of faith that we're not just here to cause a delay. We've applied our minds. And what has the application of our minds brought us to, my lord? If I could indicate, and of course this is not the time to argue the matter, it is, the previous legal team stood at a crossroads where they were considering a review of the failure of the representations of Mr. Zuma, alternatively a permanent stay. We have assiduously looked at the matter and decided definitively that a review would not be appropriate, and we've discarded that as an option. So progress has been made. We have also, though, decided on the evidence that we have available, and there's much more that we have asked for, which will guide us further in the nature of the application that we will bring, that a permanent stay is a very realistic option and has great prospects of success. However, there are a lot of documents that we have called for. They may otherwise have emerged as part of records of decision in review applications if such were brought, but we have declined to bring review applications as some kind of mechanism for obtaining discovery, if I can put it that way. We have written to the National Director and asked for the documents, and we trust that they will be forthcoming. Of course, they are not yet forthcoming. It's only 2 days old, the request. But it is entirely unrealistic. I know my learned friend, a man of integrity, wishes to pursue his brief to get on with the prosecution with the kind of alacrity that he feels is appropriate. But Mr. Dana, in all his goodness, cannot dictate to me, Michael Helens, and my team, Mr. Sikani, Mr. Jubir, Mr. Masuku, and Mr. Sikakani, that he knows how long we need to get a very substantial application together when we don't yet have all of the papers of Mr. Kemp to start off with, but more particularly of the substantial nature that we requested from the state. Now, turning my words into something more concrete, let me say with sobriety and some dismay on behalf of the South African state, that the 4 pillars of this permanent stay application are going to be a delay in charging, known in constitutional law as charge delay, a delay in coming to trial, known as trial delay. But there are 2 far more ominous aspects to the permanent stay application. And the one is significant pre-trial irregularities in the conduct of the investigating authorities, the DSO as it was then called, and the NPA. And I mention only two aspects, very serious constitutional implications. The Browse Mole report, where the DSO, with no lawful authority, were eavesdropping, telephone tapping, and spying on Mr. Zuma, and compiled a report as if this was some Cold War operation of the 1950s or 60s. The spy tapes, and it's not a rehash of that which served before the Supreme Court of Appeal, but it is the significance in terms of pre-trial irregularity and the undermining of the constitutional principles of privacy and regular conduct vis-a-vis any suspect, that the SARS spy tapes will come into being. And then more ominously, and it's sad for this country, executive interference, executive at the highest level interference with prosecutorial independence. Now, my Lord, I won't say more about those 4 pillars now, because this is merely an application to arrange dates. But as you will appreciate, a responsible team of advocates, led by a responsible attorney, cannot lightly produce papers covering a 17-year period, making such serious allegations as I have foreshadowed, and be told, take a month to do it, and we haven't yet given you the documents. I know we're not out of time to give you the documents, but we think you can do it by end of August. My Lord, today is nearly the end of July. We are entitled to take a brief. We also have lives in our own professional lives. I know Mr. Downer may have other cases to prosecute, but I suppose he can farm them out. We have some things in our diaries already, but we give this matter priority, and we say to you in all honesty and professional forthrightness and responsibility that we believe mid-November we will have a formidable application ready for the state to answer. And we need that time. I have my team working on a chronology, gathering every document, court record, judgment, letter, correspondence, notes on meetings from 2001, when this matter more or less began, till the present day. As we speak, there are new statements coming in from the state. We know one is coming. And we also know that the state, in all its holiness and its readiness for trial, are considering amending the indictment at this late stage. Now, although that may be only against accused number 2, it brings to light the possibility of further statements. We understand there is a possibility of further statements. And there is always a knock-on effect in atmosphere, in the nature of evidence being led. If there's another charge against accused number 2, it has to somehow relate to Mr. Zuma, and we would have to take that into account. So the State's House is not in order. The State's House is subject to further investigation going on and a potential to an amended indictment. So we say, with great respect for Mr. Downer, he pushes us too far. He pursues his mandate too vigorously, and if he were to succeed in persuading your Lordship that we have to bring this application by the end of August, he will create even further delays than would otherwise occur if we had the time which, in all responsibility, we indicate to you we need. And when one views it practically from the other end, it seems highly unlikely that the permanent stay, given the time even more shortened than we would ask for, necessary, because to complete the set of papers there would have to be an answer, and I make this promise to the court and my learned friend, it will be a substantial application, not only in volume, but in weight and content and seriousness for this constitutional democracy. So a rush to put us to produce a document which will take a substantial time to answer, and then there would be time for reply, this process will not terminate this year, and we will clearly have a hearing in February or March next year. So why put us under pressure to hit a timeline that will result in any event in a matter being heard next year? And with a great potential, I give your Lordship the assurance that it will be the end of the matter. There will not be a trial, but that will be the decision of the judge hearing the matter. So, and on the question of the hearing, I believe it will take at least a week for the hearing. It will be a substantial document. We agree that the 30th of November can be a holding date or provisional date. And we give your Lordship assurance. We read in the press that seems to be running this country at the moment, that there are Stalingrad tactics being employed. Well, this is not Stalingrad, this is Pietermaritzburg. I am an advocate of this court, a servant of this court, And we need that time to do a responsible job against not only the former president of the country, but just an ordinary citizen of this country. He's entitled to a full and adequate defence, and we ask your lordship to give us the time. So on the one hand, we stand on principle that we need that time. On the other hand, we stand on practicality. This job is not going to be done with a rush, and a rush will frustrate the doing of a good job. I believe my learned friend in his heart of hearts would understand that when this team of lawyers tells him that's what we need, he really knows that's what we need, but he's trying to press a case in terms of his instructions, which are not ominous or subterranean. Simply, they want to get on with it, but things have passed at that moment, and what we submit to your lordship, we believe is a responsible attitude. So we would ask that we be ordered to file our application for a permanent stay by mid-November, and let me give that a date. The 16th of November, I would suggest, and that your lordship, so we would be ordered to file our application for a permanent stay by the 16th of November 2018. That your lordship postpone the matter, as my learned friend has indicated, to 30 November 2018 as a provisional date. On that date, obviously, we will be able to assess where we are. I do confirm that we've agreed between ourselves, Mr. Katz and Mr. Downer, that in terms of which rules of court or the mechanisms for the application and time limits, normal time limits such as provided for in the Uniform Rules of Court would not apply, and we would agree generous or reasonable time limits between ourselves. Even that concession between all of the parties indicates to your lordship that there is a recognition that we, as the representatives of the respected parties, are setting about this job in a responsible manner, meeting each other in a responsible way. So the only difference really is Mr. Downer, with no information as to what I'm going to put in the application, how much reading we can have done in the short time we've been briefed, how much reading we need to do, and how we're going to construct our case, says with an empty or a hollow resonance, give them a month. Well, Judge, a month is not enough for us. We need mid-November. So we would ask postpone the matter to the 30th of November and order us to file our application for a permanent stay by the 16th of November. This matter will be heard in any event next year. Thank you. Thank you.
Thank you.
Thank you. Mr. Kurtz.
Thank you. Thank you.
There's one issue, my lord. It's a footnote. We are ready, and there are not going to be funding problems with this team. It is so that there is some litigation still outstanding about costs and funding, but the outcome of those things are not going to affect our attitude. So you can rest assured that this team is here and here to stay. Thank you.
So, okay, Mr. Helens, on the previous occasion, it was indicated that the accused number one still wishes to pursue the review application. Do you agree with Mr. Downer that is no longer an issue?
Sorry, my lord, I thought I'd mentioned that, but let me deal with that. We as a team have looked at that question of review and decided that it is not a good option, not a viable option, and not one that Mr. Zuma chooses. So your lordship makes an extremely valid point. Progress has been made, because otherwise there might have been a review and thereafter a permanent stay application. We're over that hill. We have abandoned any thought of a review, and we are firmly fixed now on the permanent stay application. So there is greater clarity from the last occasion. Your lordship is right to ask me.
Okay, thank you. Mr. Kurtz?
Thank you, my lord. My lord, let me place on record accused number two's attitude to the various issues that have arisen, and in particular the arguments that have been made by Mr. Downer and Mr. Helens. In the first instance, we agree that it would be appropriate that this matter, the criminal trial, be postponed to the 30th of November 2018 as a holding date. The one caveat to that is that I mentioned in my introduction this morning that the representative of accused number two is not in court, and we would ask that a similar ruling be made, that this matter be postponed to the 30th of November 2018 without the need for that representative to be in court. We have not, our legal team have not discussed that date with the representative, and if there was a problem as to her availability, that could rise an issue. But Mr. Downer has indicated that it seems to him that there would be no problem with such an order. So that's the first thing that I'd like to place on record. The second thing, in light of that, we would also like to indicate to the court that our client has at all times over the 17 or 18-year period attempted at least to cooperate with the prosecution. And in like manner, in leading up to today, we have attempted at all times to cooperate with what we would describe as a prosecution based on some type of integrity, at least as far as arranging the court dates, etc. I would like, however, to place on record what our stance is in respect of where we're going forward. And the first aspect is that our instructions are that we do intend to bring a permanent stay application. We have received a response, if one can call it that, to our representations. We received it 2 days ago, and I'd like to hand up a copy of the response to the court with the leave of the court, because I'd like to just place on record certain of the aspects that arise from the response. The first is that we put our representations in to Mr. Downer on the 6th of June 2018. The response did not come from the DPP or Mr. Downer, but it came from the National Director of Public Prosecutions, Mr. Abrams. And I'd like to just take the court through it, because your Lordship may wish to make certain orders arising from what's contained in the response of Advocate Abrams. The first, there are 5 paragraphs, short paragraphs each one. The first says your representation submitted on 6 June 2018 refer, and this is dated Advocate Abrams' response is dated 25 July 2018, so he took, say, 6 weeks to respond to the reps. He says in paragraph 2, after careful consideration of the matter, I'm of the view that there are reasonable prospects of a successful prosecution against your client. I just wish to place on record, it's a point that we will make at some later stage. Don't want to argue our case now. But that consideration is a non-response, because our representations did not go in any way to the prospects of the successful prosecution or otherwise. Our representations indicated one issue and one issue only, and that our client can't obtain a fair trial. And the prospects of a successful prosecution against our client were absolutely irrelevant to our representations. We have no doubt that Mr. Downer read our representations, but we're not sure that, bearing in mind what is contained in this letter from Advocate Abrams, that this is an appropriate or indeed a response at all to what is contained in our representations. His next paragraph says, because of that, your representations are thus unsuccessful. Well, we submit that that's a non sequitur, because that wasn't the basis of our representations. And now in paragraph 4, there's something that we would regard as unfortunate on 3 different, or at least 2 different levels, and we would ask that your Lordship make some order in respect of paragraph 4. What Advocate Abrams says is, I've also requested the prosecuting team, that would be Mr. Downer and his colleagues, to provide me with their views on the prospects of preferring charges against your client in terms of Section 5 Sub B of Act 12 of 2004 in Subcount 2 of Count 3. Now we've looked at Act 12 of 2004, I have it in front of me, and we don't see a Section 5B. There is no such section. And we find that unfortunate that the National Director of Public Prosecutions can, after taking 2 months to consider our representations, can refer to a section which, in our view, perhaps wrongly, doesn't exist. Perhaps it's a typo, perhaps there's some other difficulty, but we find it unfortunate. We also find it unfortunate on a second leg that the prosecution team have indicated to the courts and to us that they are ready for trial. And yet here we see what we would regard as a possible amendment to the indictment. So can it really be suggested that the prosecution team is ready for trial today, or they said 3 months ago. So we have certain concerns, and our client certainly has certain concerns. The third aspect on this issue, which I'd just like to indicate to the court, is that we've read in the media that there is a particular person who has provided a 17-page statement to the investigating officer in respect of this case. We haven't seen it. I've discussed it with Mr. Downer. He's indicated quite fairly that he will provide it to us. We don't know what it says. We don't know how it would, could, or should influence our client as far as the criminal trial, as far as the representations, as far as the permanent stay application is concerned. So what we would ask the court to do is to put the state on terms and make an order that by a certain date, maybe a week, Mr. Downer gives us what he would regard as the final indictment, close of all options of charging my client with a section which may or may not exist. And if there are further affidavits that have come into the possession of the investigating officer in the investigating team, they provide it to us within this particular period of time. Once that has been completed by the prosecuting team, we will be in a position, we suspect, to launch our permanent stay application within the time period that Mr. Downer has indicated. The papers are on an advanced stage. We've already started preparing them. And we would, in principle, subject to this issue of the new charge and any new evidence that has come to light, to launch our permanent stay within, say, a month, 6 weeks, as indicated by Mr. Downer. So we would ask that, one, the criminal trial be postponed to the 30th of November 2018 with the express provision, the express understanding that the representative of our client need not appear. Number two, order the state to indicate to us through our attorney exactly what the final indictment will consist of, and if there are further affidavits that have come to light, they be ordered to give it to us within this, say, short period of time. As far as the permanent stay application, your Lordship has heard what I've got to say, and we will fit in, and as we have done in the past, cooperate in any way that we can. As it is.
So how much time do you need?
Excuse me, sorry, Simon.
How much time do you need for a permanent stay application?
Yes. We don't have an objection to either the timelines suggested by the prosecution nor Mr. Helens. If the court orders Mr. Helens' timeline, we have no objection. If it orders Mr. Downer's timeline, we have no objection. Subject to this question of the amendment to the indictment in respect of our client and any further evidence. If, for example, in 3 weeks' time there's an amendment to the indictment, all my offer of no objection to Mr. Downer's timeline may have some limitation. So we would suggest we need to know what is the final amount, what is the evidence that we are facing, what is the final indictment that we are facing. Once we have that, we will be in a position to comply with any timeline that your Lordship orders, whether it be Mr. Helens' timeline or Mr. And we're agnostic really on that, subject to protecting our rights as far as the fair timeline is concerned.
Do you agree that both of the applications will be heard together?
Yes, the question that I understand Mr. Downer and Mr. Helens to have some interest in is whether our client agrees that both permanent stays be heard together. That is that of Mr. Zuma and that is of our client. We're not in a position, and we don't have instructions to agree that those two applications should be heard together. However, were the court to order that the two applications be heard together through some consolidated means, through some court management scheme, it would be difficult for us to think of a realistic reason to object. Subject to this, in our view, the appropriate mechanism for the relief that our clients intending to seek would be a civil case. Under Rule 6, probably wouldn't be under Rule 53. You've heard that we agreed, the three parties have agreed that the strict timelines set out in Rule 6 wouldn't bind the parties. But what we wouldn't want to necessarily do is agree that that Rule 6 application be heard together with some other application which is part of the criminal trial. So we would have to see how it worked out, and we don't have a serious or a principled objection for the two applications to be heard together, but it would depend. It would depend on the contents, it would depend on when they brought it, it would depend on your Lordship's order. So that's where that's our position as far as that. But we will cooperate in whatever way we can, but we do require the court and the state to indicate what it is that we are facing, and if there is new evidence that the investigating team have in their possession vis-a-vis outline, we wish to see it as soon as possible, as it pleases. Excuse me, my lord.
Okay. Mr. Downham, do you have any?
There are some points, my
reply?
lord.
Yeah.
Sorry, are you finished?
Yes, I'm reminded by Ms. Adhikari to just make the point that as far as Mr. Downer's timeline is concerned, we would cooperate with that timeline subject to how it is that your Lordship deals with this question of the new charges and the new evidence that may or may not be up there, as it pleases your Lordship.
Yes.
Please, the court, my lord. Just a couple of replies. My lord, both my learned friends have raised this issue of the new charge. And might I just say up front that we agree on the side of the state that we will very, very soon, and certainly within the week that my learned friend for accused number 2 proposes, indicate what the position is. I might also just place on record, as it's evident from this letter, that we received a request from the National Director to advise him. We advised him immediately on receiving such a request on the same day. So the advice has been done, and from our point of view, the issue ought not to affect the further conduct of this trial at all.
Okay, what do you say about Section 5B, which Mr. Kurtz alleges that it does not exist?
There is no Section 5B of the Prevention of and Combating of Corrupt Activities Act 12 of 2004. There is a 5.1b, and there's a 5.2b as well, in 5 in brackets 1 in brackets 2. I agree, there is no such charge.
Okay.
So, yeah, there's a 5.1b, indeed. As I said, it ought not to affect the further conduct of this trial. My lord, let me also just place on record that I'm extraordinarily grateful to my learned friend for accused number 1, Mr. Zuma. Your Lordship might not know this, but it was, I think I'm right, in this very courtroom, before another of your Lordship's brethren, that I appeared, and a previous counsel for accused number 1, Mr. Zuma, and where it was placed on record that going forward, the tactics of accused number 1, Mr. Zuma, were going to be and were akin to a Stalingrad tactic. So that Stalingrad tactic, the Stalingrad approach, came not from the press, not from some construction of commentators relating to the proceedings, the very lengthy proceedings that have occurred in the last decade or so and more for this case. They came out of the mouth of previous counsel for accused number 1. As I understand it, Mr. Helens, my learned friend, has abandoned the Stalingrad tactic. And as far as I know, this is the first that this has been put on record in court or in any forum, that this is a tactic which previously persisted and had been adopted seriously, but that had in fact been abandoned. So for that, we're extraordinarily grateful. We take it very seriously from our learned friend. I would have expected nothing less from our learned friend, Mr. Helens, whom I know very well. And he's been complimentary all round, so we can return the compliment. That being so, we nevertheless have suffered as a result of those tactics by the various delays. That will be part of our argument. My learned friend will have some arguments to the contrary. That's all fine, that will duly, but that explains our disquiet that we are now a year down the line, nearly a year down the line from the decision to cancel the previous decision not to proceed with the charges, and yet we are still involved in preliminary litigation. I take on board everything my learned friend has said about the time he needs, etc. I would ask this court to take into consideration that background and to hurry us all along. Just some other points. We all agree on the holding date. We all agree relating to the excusing of accused number 2's representative. And my Lord, let me just put that in perspective. Again, this is now the second time that we will ask the court to excuse her. It's a peculiar circumstance because accused number 2 is a corporation. So there is no person actually really necessary, and there's no prejudice that would be suffered by the absence of the representative. That could be any representative at any stage of the trial at the state's election, obviously in consultation with the representatives for the corporation. So it is of no moment, and we rely on the assurances that whenever we need a representative, that representative will be available and will be in court. So I place that on record. I'm also grateful to my learned friend for those assurances. My learned friend for accused number 2 said that he regarded the NDPP's answer that he thinks that there are reasonable prospects of success as a non-answer because it was not an issue in the representations whether there were reasonable prospects of success. I think one can say that it's not quite correct because the reasonable prospects of success would include the prospects of success of a fair trial attack. It's not just on the merits, obviously. It also would depend on an appraisal as to whether the NDPP and we thought that a permanent stay application, for instance, or other fair trial litigation would be unsuccessful. So that is certainly what is meant by the reply. Reasonable prospect. It means including everything. We think the state would succeed. As far as the further statement is concerned, and that goes together with our assurances relating to a final indictment, my Lord, might I just say that we will absolutely give that assurance that it is a final indictment. That obviously doesn't at any stage preclude the state, in terms of the rules of court and the Criminal Procedure Act, from applying for an amendment to the indictment. It happens in every criminal case, in every court in this country from time to time. It doesn't affect the nature of the finality of the indictment. We certainly, apart from this tiny glitch, we certainly don't intend amending the indictment, but we can never guarantee that we will never in the future ask for an amendment to the indictment. It's actually a non-issue because we all agree on that, and whether it's merited or not will depend on the circumstances. That doesn't affect the conduct of the trial and applications for further, for permanent stays, etc. And as far as the further statement is concerned, I might also just say that it's a common complaint from criminals, from criminal counsel, from representatives and from accused, that the state doesn't finish its investigations prior to a trial. And if there is further material which emerges, then there's a hue and a cry about, but why is the investigation continuing? All I say is that there's law on these issues, and we certainly, if anything new crops up, we give it immediately to the defense because they're entitled to the contents of our docket, and we've already assured my learned friend that we had already decided that they will be placed in possession of this new statement. So we give our, in fact, they'll get it today. The investigating officer has the details of counsel and the attorney, and it will be provided to both sides. And as to the hearing of the two applications together, once again, I think it's a mark of extraordinary progress in this case that counsel can agree on a general approach, and we give our assurances on the side of the state that we'll work something out between counsel now that counsel is not adopting a Stalingrad approach. And we don't think that there'll be any hindrances to us being able to reach sensible accommodations to get this matter going. And my learned friend for accused number 1 thinks that the matter won't go after the permanent stay. Well, obviously we think that it will. But that, of course, is a disagreement which will be determined by the courts in due course. Okay, I think that's all, my Lord, unless there's anything further.
Lord, may I make one submission? My learned friend seems to paint me with a brush that would suggest that I'm very familiar with the Stalingrad tactic, so familiar that I may even have been to Stalingrad. But what I meant to say, and what I think I did say, was, well, I've heard about this phrase. It does not exist in this team. We were briefed, we looked at what we could, We decided no review, we decided permanent stay, we looked at time limits, and they are what we have suggested to your lordship. So let me not be party to saying I've abandoned Stalingrad tactics and I'm now heading directly for Moscow. We got the matter and we said we will deal with this matter. And we asked for the time that we've asked for. And let me say, my lord, my learned friend for number 2 might be ready sooner. It doesn't help him to be ready sooner if we all agreed, more or less, that we're going to go to court at the same time. Give us the opportunity of putting together a proper case which will be determined within a reasonable time, given a 17-year time frame against which today has to be seen. But thank you for the indulgence, madam.
Thank you. So when this matter was adjourned on the 8th of June, to this date, it was brought to the notice of this court that the defense for accused number 1 might need time to raise funds depending on the outcome of an application lodged in Gauteng. And secondly, that it will also consider bringing up a review application. Today, this court has been assured that the funding issue does no longer exist, and further, the defense for accused number 1 is no longer wishing to pursue a review application. The issue which has propped it up today from the fact that both defense for accused number 1 and 2 wishes to bring an application for a permanent stay, which the state does not object at the moment, that there should be such a moment. But the problem which has arisen is the time period between which such application can be filed. Accused number 2 on the last occasion was excused from further attendance today. But accused number 2 is represented by Mr. Katz. Let me deal with the bigger issue, because Mr. Katz is in between. He goes with Mr. Downer, and on the other hand, he also goes with Mr. Helens. So it must be, at times, you may find him hunting with the dogs and running with the hares. Mr. Dana has proposed that 4 weeks will be adequate for the filing of the contemplated application. He says the issues which must be contained in the application will be issues which all along have been in contention between the parties. So, in order not to delay the proceeding any further, the time for filing should be shortened. On the other hand, Mr. Helens has got a different view. because he says, taking into account or into consideration the 17-year history of this case, secondly, the fact that there are a new legal team in this matter which is not conversant with the proceedings or which has not been involved previously, and the voluminous of documents which could be involved in the matter, they need time more than 4 weeks to file this application. And in his view, in any event, the application will not be had this year. It could be had next year in the first quarter of the year. Mr. Katz, for accused number 2, well, to him, 4 weeks will be appropriate. But if 4 weeks not granted, more time than 4 weeks also will be appropriate. So I would not go much into details with into his stance in this regard. Then his stance will be informed by the decision of this court. So every trial in terms of law should be fair. So in the circumstances, one has to take into account in deciding the time period whether the fairness of the trial will somehow be prejudiced by not giving the defense an adequate time to prepare its application, and whether the time considered will be adequate for the defense to prepare its application in the manner one could say that one could say that the accused has a fair trial or a fair and adequate period to prepare. Well, one may be eager to get the matter finalized, but the circumstances may not go along with that wish. Mr. Katz has raised, or after Mr. Downer also has indicated that the director, the National Director of Public Prosecution, is contemplating adding a charge, an additional charge to accused number 2. But surprisingly so, both agree that the section under which that charge could be brought does not exist. So we really don't know where the National Director obtained that section from. Maybe, I don't know. That should be cleared. And what kind of information or evidence has been gathered to necessitate such a further charge? That's what Mr. Katz wants to know, so to be able to prepare. In other words, so far the indictment is not yet final, because some more charges are going to be brought onto the fore. So that also should be taken into account and in computing the time period. Well, all the parties have agreed that this matter should be provisionally adjourned to the 30th of November. I think all parties agree. Mr. Helens has also indicated that there were some kind of irregularities and a lot of things. I will not go into details. Even alluded to the executive interference in the matter. That on its own may take the defense some time to probe into that with a view to finding grounds for the application, and if the application fails as has been thought, which I don't know what will happen to the application, but if in any event, if it fails, then the defense will be still in a position to prepare for any proceeding which may later ensue. So taking all these factors into consideration, I come to the conclusion that a 4-month period, a 4 weeks period would not be sufficient for the defense to prepare and to gather the necessary information for the contemplated application for stay of the proceedings. Mr. Helens has alluded to 16 November as the date by which the defense will be in a position to file this application. Obviously, the time the state will need will be somehow informed by the contents of the application. That could be decided also on the 30th. I think that will have time to be attended to on the 30th. So let me start with this non-existing section. That the state is ordered to provide Mr. Katz for accused number 2 with a final indictment within a period of 14 days, and to clarify the issue relating to the section in dispute, which is referred to in the letter dated 25 July 2018 as Section 5B of the Prevention and Combating of Corrupt Activities Act 12 of 2004 in sub-count 2 of count 3. That should be cleared because both the state and the defense agree that that section does not exist. The one which Mr. Downer has said that it exists. We don't know whether it makes the same provision or not. That should be cleared within this period I've indicated earlier on. And now coming to the time period, as I've said earlier on, that I also think that at least a 3 months period will be sufficient. So, which means that the defense will be ordered to file its application on or before the 16th of November 2018, and the response thereto, or the time period for the response thereto, will be determined on the holding date. I think at that time the state will be in a position to know where it stands regarding its response and what time period it needs. And Mr. Zuma, will you please stand up? By agreement or by consent, your matter is provisionally adjourned to the 30th of November 2018 in this court. You are required to attend court on that day, and you will be released as before on your own recognitions. I assume that you know what may follow if you decide not to attend court on that day, which I don't think you'll do. And with regard to accused number 2, there has been agreement that she will further be excused from attendance on that day. I don't think I've omitted anything. Is there anything omitted, Mr. Allen?
I don't believe so.
Mr. Downer?
No, Lord, I think that was very full. Thank you.
Oh, okay, thank you. Thank you, Mr. Zuma. You may be excused. Court adjourns.
Well, court has now been adjourned this morning in the case against former President Jacob Zuma. It has been provisionally adjourned until the 30th of November 2018, and the former president will be present in court on that day.